Culbert, and she's the director of the Loyola Center for Conflict Resolution at Loyola Law School, and she's very well versed in dependency mediation, so she's going to give us a little bit of an explanation about mediation ethics.
Okay, so I just wanted to also introduce my partner, Sarah Campos. She's in dependency court on Mondays, and I'm in dependency court on Tuesdays. And you know, the Randy and Stacey's program is Wednesday, Thursday, Friday. So part of what I'm saying today about what we say to our folks, what we promise as mediators, may differ a little bit with Randy and Stacey, but the law is the same. Okay, so part of mediation ethics is that we have to maintain confidentiality, and we have to describe confidentiality at the outset or before mediation. So that's the first thing we do as mediators in dependency court, but there's a new law that's effective January 1st, 2019 that says that you, the representing attorney, have to provide the client with a printed disclosure containing the confidentiality restrictions in section 1119 and obtain a printed acknowledgement signed by the client stating that he or she has read and understands the restrictions. So I guess in order for them to understand the restrictions, the first person that has to understand the restrictions is you. Because they're going to come, they're going to say, what does it say? So, you know, here's the thing. I work with law students, I teach them mediation confidentiality, as I was saying to Jessica, for 6 hours. And so you have to give this acknowledgement to your clients and have them sign it. And what it says you have to do is you have to do it right at the beginning. So it says, except in the case of a class or representative action, an attorney representing a client participating in a mediation or a mediation consultation, which I'll tell you what that is in a minute, shall, as soon as reasonably possible before the client agrees to participate in the mediation or mediation consultation. So technically this should be done before mediation day. If you don't do it by mediation day, at least on Monday or Tuesday, we're going to have copies of the notice and acknowledgement. So you got a couple of handouts. One is, it says Loyola Center for Conflict Resolution Agreement to Mediate. And the very last page, Mediation Disclosure, Notification and Acknowledgement. So that works. This works. If you have your client read this, now here's a couple of things that you have to comply with. It says that in section, so 1129, California Evidence Code section 1129 is the new section that requires you to get this from your client pre-mediation. Now I know that I spoke with Judge Trent Acosta, and he's going to try to see if the court can do something, you know, from the court that everybody gets one of these right away, so that it's not something that each of you has to deal with. But until that happens, ethically you're required, as of January 1, anytime you send a client to mediation, to get this signed. It has, now the reason I pulled this off was a little dramatic, because it says in the statute it can't be attached to anything. So it can't be attached to my evidence code or my agreement to mediate. You have to give it to the client, you have to sign it, and they have to sign it. So basically it says that it has to be in at least 12-point font. This one is. It says it has to be in the preferred language of the client. We will have them in English and Spanish, and hopefully within a month or so maybe in Armenian. Generally speaking, if somebody speaks English well and they come to the mediation and they're fine with the mediation being in English, but their preferred language for reading is Russian, technically you're supposed to give it to them in Russian. So I think the court has to deal with that. For any one of you to go and, you know, get these translated yourself is a little bit too much for anybody to do. So again, we will have copies of these in English and shortly in Spanish, and we have a student who's going to translate all of our stuff into Armenian. If you have a mediation, so that's why when you're signing up for mediations, if you need to have this in another language, you can let us know. If we have a student, we can ask them to translate it, but generally speaking, that is an ethical duty of yours, and it's an ethical duty that the court is looking at, so the court realizes. So, and you know, there are more than 222 languages spoken in Los Angeles County. So you'd have to have a file of 222 languages if you were going to give it to every person in there. So the thing is, they can't sue you for malpractice as a result of not doing this, but they can file an ethical complaint against you at the state bar. So obviously, for them to sign this, that they understand the restrictions of mediation confidentiality, you have to understand them. So, you know, I've been a mediator, Sarah and I have been mediator probably for 50 years between the two of us, and lawyers often don't understand mediation confidentiality. And it takes a lot of time to understand it really completely, but hopefully within this hour today, you're going to understand confidentiality for dependency court purposes and what happens. And it is a little bit different. Okay, so again, a mediator's duty is to discuss it before or at the outset, so that's the first thing we're discussing with your clients. The other thing is, where do you find confidentiality? You find it in the evidence code. Obviously you have it's attached here to our agreement. You'll find it in California Evidence Code section 1115 through 1129. 703.5 says that mediators are not competent to testify, except maybe in a state bar proceeding. So you can read 703.5. It limits where a mediator could possibly testify, so it's a waste for you to try to subpoena a mediator. We're protected. So really, from my perspective, there are three different parts of mediation confidentiality in order to understand it. So everyone knows about the attorney-client privilege, right?
Yes.
Okay, so the attorney-client privilege, basically, where do you find the attorney-client privilege? Where do you find that in the law?
In the evidence code.
In the evidence code, right. It's in the same place that you find the confidentiality statute. A lot of times you're going to read cases about mediation confidentiality, and it's going to refer to the mediation privilege. I want to tell you that they're using that term generically. There is no mediation privilege in California like there is the attorney-client privilege. So you all know that a privileged relationship is granted special status under the law. You find it in the evidence code. The default is that your communications of the people in that special status relationship, they're considered confidential, that there is what's known as the holder of the privilege, so only the holder can waive it. Who's the holder of the privilege in the attorney-client privilege? The client. So if you go home and you talk to your spouse about confidential attorney-client communications, what are you doing? Are you waiving the attorney-client privilege? No, you can't, because you got the holder. What you're doing is you're violating the rules of professional conduct. So you're violating the ethics of an attorney if you're disclosing attorney-client communications. But if you disclose communications, it does not waive your client's rights to assert that confidentiality in court. Why am I talking to you about the privilege? Because part of mediation confidentiality includes case law interpreting the statute. So you'll find mediation confidentiality, it's the statute 1115 through 1119, and there's case law interpreting that. So you have to read the statute, understand what the statute says, then you have to look at the case law to say, hey, what does the section really mean? So it's a little bit complicated. Again, I'm going to throw it out at you real quickly and in a real shortened form. So here are the three parts of mediation confidentiality. Let's get to the heart of it because we're short on time. One of them is, what does your mediator promise to you? I can tell you what we as mediators on Mondays and Tuesdays promise to you because we have this community program at Loyola. We've had it since 1992. We've served 50,000 people. We have a lot of policies and procedures. We have 350 cases going on at Loyola. So if you think of legal aid, we're like mediation aid. So Loyola's had this program to serve the community for a lot of years. We've served a lot of folks. We have a lot of policies and procedures. We've only been in dependency court for a year and a half, and it's a little bit different. Is it okay if I close this door here?
Close it right
Okay, great. Okay, so the first thing that we do in our community program is we tell, and this is the first thing that we say to your folks when they come to our mediation, we say, look, this is a confidential process. What that means is we're not going to tell anyone that's not in your mediation session what's going on in here. There are a few exceptions. One is the attorneys. We see your attorneys that have to be in court all day, we see them as part of the process. You're here in this mediation because your attorney or the court decided that you should be here, your attorney agreed, your attorney scheduled this. So do we go tell your attorney, hey, you know what this person said, and tell them everything? No. But when your attorney says, what happened in that mediation, we're going to tell them, well, it's settled for this, or it didn't settle, and here were some of the concerns. So we tell people right on the front end that even though you folks are not sitting in the room, we're going to tell you a little bit about the process if you ask us. I know that Randy recently, he goes and he grabs you folks before the day begins and he talks to you about your cases. We don't do that. We come at 10 and 10:15 by appointment, and basically we go look at the file. If you're willing to come at 10 or 10:15 and tell us a little bit about the case, it really can shorten the process for us. So again, here are the issues, here's the court's parameters. Obviously, we're going to go look at the file. Sometimes we can't get the file. Sometimes it's an old file that's not on the new system. So we go there and we say, here we're the mediators and here are the parties, and they will give us a special code to get into the file. Sometimes we can get in, sometimes we can't. So anytime you can stop by and give us a snippet of what's going on in your case, you will save a lot of time. Okay. So we make this promise. The promise is we're not going to report anything back to the court. We don't talk to anyone in the outside world about what happened in your mediation. We don't even tell people that you came to mediation. So we really, really protect confidentiality. Here is the exceptions. One, we got to tell the court if there are new credible allegations of abuse or neglect. So if we learn of something about that there's new allegations of abuse or neglect and they seem credible, we are required to report. So we make sure that everybody understands that up front. We give them an agreement to mediate. You've got a copy of it. It says all of that in there. They sign it. Okay. In the opening statement of the mediator as to what the process is going to look like, that's where you folks should have already had them sign that notice and acknowledgement. So again, the third part of our promise is that a caucus session, which is where we meet with one side and not the other person in the room, that is confidential. It has its own rules with respect to confidentiality. So if I meet in a caucus session with you, I'm not going to tell the other person what you're telling me without your permission. So it's empowering to an extent. I know that a lot of folks, when they get into dependency court, there are a lot of people making decisions about very important issues in their life, and they can tend to be very upset. A lot of times they come to us and they said, we just want to get out, and they decide that they want to make the decisions themselves instead of having the court make the decision. Sometimes it's very hard for them to make the decision themselves. And, but, you know, we've been doing this for a while, so we have a way of kind of walking them there. When we do mediations, this is a little picture of the world. We'll come back to this one. Here's the world. So I've got this as the world. And here's the courthouse, and here's our mediation center. You should know the court does not let us discuss the case with your clients pre-mediation. So it's standard policy for mediators to do what's known as intake or convening of the case and to get a lot of details about what's going on and the viewpoint. But because of confidentiality, the court doesn't allow us to do that. The court will allow us to call and confirm, are you coming? A lot of times we call and they don't answer. So that can be a little bit frustrating, but basically the court allows us to call. Once that schedule gets made, we get notice that attorney so-and-so has scheduled a mediation and here are the parties and their phone numbers, and we call them. What's really good for us to also get, that because the clerk wants this before they'll give us the number to look at the file, is the number of the file, the language that the person wants the mediation in. and the child's name. So a lot of times, in re matter of the child. So if we don't get the child's name, it hasn't been too much of a problem, but they've asked us to get it. So if you can put that information when you're reserving a space for mediation, that would really be great. Again, the child's name, the case number, the parents, and the parent's phone, and the language. Okay, so here is the courthouse, and here is the dependency. So what we usually say, because people are calling us to do a mediation here, we say, look, anything you tell us, we're not going to share with anyone in the outside world. Okay, and here's the world. We're not sharing it with anyone here. We're not. That's what we tell everybody when they come to our mediation center. But when we go to dependency, our mediation program is here in the dependency court. So there's 2 layers of confidentiality. So the confidentiality that we are promising people is within this system called dependency, which is another layer of confidentiality. So there's like 2 layers, and remember, people are trying to get out of here into the family court. So we've already got 2 layers of confidentiality before they get here. So the California Evidence Code, again, there's a mediator's promise. Caucuses are generally considered confidential. Ethically, I believe that you're supposed to tell people about confidentiality. You're supposed to tell, as a mediator, you're supposed to tell them about what you're going to do with their confidential communications from those caucus sessions. Some mediators don't do it. I think it's unethical personally. I don't have a problem saying it out loud. I once taught mediation ethics, and there was a mediator lawyer there, and I said, basically you're supposed to get permission from one party when you go to the other meeting with them. And this guy said, wait a minute, I'm hired to settle a case, so I'm gonna do whatever I have to do to settle the case. And I said right out, I think that's unethical. And some of the other panelists that are trying to make a living by getting hired, I'm not. I have the luxury of saying things that are offensive because, like you, I'm a salaried person. But the point is that I believe that people are supposed to tell, under the ethics, mediators are supposed to tell the parties what they're doing with their confidential communications. And by the way, when we call them, the very first phone call before the mediation session, so here's the mediation session, and we have a first phone call in dependency court, is really to say, hey, we want to confirm that you're going to be there, right? So, but from that very first phone call, under California Evidence Code section 1115, it says you are now in a mediation consultation. So those communications for purposes of convening a mediation, those are called mediation consultations. And so that's 1115C describes a mediation consultation, and 1119A says all mediation consultations are confidential information. So technically, when you're having a conversation with your client pre-mediation about them going to mediation, there is a more than strong argument those are confidential mediation communications. So again, we're talking attorney-client privilege, we're talking mediation communications. Remember, the attorney-client privilege and the California Evidence Code, the mediation confidentiality provisions, they're both in the Evidence Code. I want to let you know that there are other states that have adopted what's known as the Uniform Mediation Act, such as Nevada. So let's say that you go out and practice privately at some point in your career, and one of the clients lives in Nevada and one of the clients lives in California. Well, there are 2 different laws regarding confidentiality. Nevada has one and California has one. The one in Nevada, that basically is the Uniform Mediation Act, and the Uniform Mediation Act does have a privileged relationship between the mediators, the parties, those are the people that are in the conflict, and the other group that's in a mediation are called participants. So under the ethical standards, under California Evidence Code, parties, the ones in the conflict, they are also participants. Participants obviously are not the parties. So if you came to a mediation or you're involved in a mediation, even on the front end in a consultation, you are considered a participant. And we have duties to the participants as well. Okay, so again, it's California Evidence Code 1115 through 1129. What does it say? It says that, I'm going to tell you the real simple form so you understand. Because this is actually section 1119, and we'll look at the language, because that duty for you to have your client sign that notice and acknowledgement says that they have to understand 1119. You have to understand it. I start out real simple, then I'll complicate it up by looking at the statute, and then I'll tell you about how some of the courts have interpreted that. So again, 1119 says that mediation discussions are confidential. What does confidentiality mean? It means they're not admissible. Where are they not admissible? They're not admissible in a later civil proceeding. So mediation communications, they're not admissible here. They're not admissible in a later civil proceeding. They're not admissible in an arbitration. So let's say we have JAMS or the American Arbitration Association. They're not admissible in an arbitration in which testimony can be compelled. They're not admissible in a administrative hearing. So I'm just going to put the California Department of Fair Employment and Housing up here. They have administrative hearings. So the law says that if I do a mediation, that all of the discussions are not admissible. Where? In a later civil, administrative adjudication, or arbitration in which testimony can be compelled. So again, 1119A says not admissible. Yeah?
I don't know if you got the key question from the people who put this together, but I am very concerned about allowing our clients to now do the family law mediation if they have a pending criminal case. Because as you've now illustrated, under the notification, it's limited to non-criminal proceedings. So my concern is, what protections do our clients have, even if they're just talking about a family law order? Should they say something pending an open criminal case? And if there's an open pending criminal case, can the mediator be subpoenaed by the DA?
The mediator can.
Thanks.
And I think that it is a concern. There's something going on in dependency court that is beyond what I know, because remember, we have mediation here, which is one layer of protection, and then we have one layer of protection here. So the question is, if somebody goes and finds himself in a family court, that's a later civil proceeding, they can't get the mediator. But let's say they find themselves in a later criminal case.
Yep.
I don't know, is the dependency court willing to send somebody to resist the subpoena to testify in that later criminal case?
We would not, because we would not, no.
But I mean, is the court itself?
No.
So there's no guarantee. I can tell you, there is no guarantee. I can tell you there are a bunch of cases in later criminal proceedings where they try to subpoena the mediator. I actually wrote a friend of the court letter on this like 25 years ago, and it worked. I know that when people were mediating in the LA Superior Court, and those were all civil cases, they later on found themselves in a criminal case, that the LA Superior Court resisted the subpoena on behalf of its mediators, and it worked. But does the statute itself say that it's not going to come in? The answer is no. Can you get subpoenaed? The answer is yes.
And all mediated agreements would be part of our dependency file, which under 827 would permit a DA to review. So the DA can review all mediated agreements, and the DA, I mean, obviously the defendant, our client in a criminal case, can choose not to testify, but they could still subpoena the mediator in to any statements our clients made as part of a mediated agreement.
Well, let me just say, as part of the mediation agreement, we have your client sign that they're not going to subpoena us. So it doesn't mean the DA can't subpoena us, but we have them sign they're not going to subpoena us. The other thing that we do with the mediation agreements is a little different than the other mediation program.
In a let's say
Okay, so hold on, just let me tell you about the mediation agreement.
Okay.
So Judge Trendacosta has asked us to take the mediation agreement and put it on the court exit forms, the judgments. So we're taking our agreements, we're putting them on 200, 205, 341C, and 341E. And then we're slapping a page on top of that says, this is a mediation agreement that we agreed to. We understand that it's now written on these court forms. And yes, we want it to be not confidential, because remember, anything written in a mediation, I didn't get there yet. Anything written in a mediation for the purposes of mediation is confidential unless you decide that it's not confidential. So our front mediation page says, we understand that our mediation agreement is put on the court forms. It says we want the judge to be able to have access to this mediation agreement. And because we want the judge to confirm it as our exit order. So we're writing the exit orders. And we have a confidentiality agreement on the front page. We also have a provision on that confidentiality agreement that says, we agreed to everything on these court forms, but here are the remaining issues to be decided by the judge. So we have a page on there that says, here are these two issues. So I know that what they're doing with agreements on Wednesday, Thursday, Friday is different than what we're doing, so I cannot speak to what the DA is getting if they're looking at those agreements. I can say that ours, they are normally signed as court exit orders, and everybody knows they're going into a family court file, and that is not confidential. So people, they're choosing for it to be non-confidential in our cases. I don't know about Wednesday, Thursday, Friday, so I hope that clarifies it. More questions about that, or should we get to the basics of this?
Well, kind of on that, because you mentioned earlier that if you find that there's a new allegation that concerns abuse or neglect, you're required to report. So where is that standard set forth, and how does it coincide with the evidence rule of confidentiality? In other words, what gives you the right to report what you think is a new allegation of abuse or neglect?
Well, that they're agreeing to that before the mediation, and also the court requires it for us to do the mediation program. It's not our choice.
The dependency court.
Yes, that's directly from the judges. So any new allegations that are credible need to be reported to the court. We tell them so there's a couple of things. First of all, the statute doesn't say it's confidential. Anything that's potentially criminal, the statute doesn't say it's confidential. And I'm not promising it's confidential. So you can read our agreement. Basically, what gives me the right? Well, any mediator can say, in order for me to do this mediation, the court requires us to say any new allegations that are credible of abuse or neglect. The court requires us to tell them that. That's a rule of the dependency court. That's not in our purview. So if they're not comfortable, they can walk right out. But that's what the court requires of us. Okay. Yeah.
If people don't come to an agreement and you are putting everything down in writing, but it doesn't come to an agreement, it doesn't get included into a juvenile custody order, do you keep your writings? Are they destroyed?
They're destroyed. So we go back and we enter a minimum into our file because we're funded by the county. So we have to have some minimal stuff in there, but they're all shredded. After every mediation, our thing is shredded. So you could subpoena our file, you're not getting anything. Yeah. Okay, so let's go on so that you can understand what time are we at? I don't have my phone in front of me.
You're at 12:47.
Wow. Okay, so, all right, so we have the promise. You know what ours is. Caucus is one of the things that you have to find out what the mediator is going to do with those caucus communications. The basic statutory provisions, which are rules of admissibility and inadmissibility in a later civil proceeding, are 1115 through 1129. 1129 is the new one that we covered already that requires you to have the notice and acknowledgement that says it and give it to them. They have to sign it, you have to sign it, preferred language, 12 font or higher. you have to, so here 1119 actually says mediation discussions, mediation writings, not admissible. 1119C says all settlement discussions, settlement negotiations shall remain confidential. So that's the subject of a lot of different case law. We didn't really know what it meant. It doesn't say admissible or not. There was a big question for us. Can a statute, an evidence code provision like 1119C, can it circumscribe our behavior out there in the world? So if it says, so let's say I'm doing a mediation and there's two people that live in this apartment building and they come to my mediation here, not a dependency court. And the question is, 1119C says all settlement discussions shall remain confidential. Well, it's a rule of admissibility or inadmissibility in a court of law. So can it circumscribe our behavior out here in the world, 1119C? And the answer is yes, I think so. There's a case called Doe 1 versus Superior Court, and it had to do with the Catholic Church. The Catholic Church, you know, there were a lot of allegations of abuse. You guys deal with a lot of allegations of abuse. There were a lot of allegations of abuse by these priests. And what happened is the Catholic Church decided to go to mediation and come clean about what they knew about the priests and when. Yeah. So they took all their employment records and they said, look, we're going to create these documents, these mediation writings, these 1119B confidential mediation writings. We're going to create these 1119B confidential mediation writings, and we're going to tell everybody, we're going to call them proffers, we're going to bring them to the mediation, we're going to tell everybody what we knew. So if we say we knew that this priest had abused somebody in 2000, and you're coming after us for $10 million for what happened in 1995, it's going to say, hey, look, we didn't know. So that's going to give you some information about the extent of our liability. But if we knew that this priest was committing abuse in 2000, and in 2005, you're trying to get $10 million from us for what this priest did in 2005, well, we're going to come clean. We're going to say we knew in 2000. So that's what the Catholic Church was doing. So they created these writings, and after the mediation, they settled it. It was a little bit over 100 priests. I think it was like 110 or 111 or something like that. And after the mediation, what they did is they basically wanted to release them. So now you see, Jessica, why I wanted both pictures. What they wanted to do is, let's say they came to our mediation. They had the mediation here, which they didn't. But now they want to release it to the media. So let's just put the New York Times there. Okay. They want to release these proffers, these mediation writings to the media. That's what they wanted to do. And the priest went to get a protective order that said no confidential mediation writings. And the court looked at 1119C and said, yes. So we know, yes, they're confidential. Settlement negotiations, 1119C. So let's look at the language of this. So, just real quickly to get through it, mediation is a process in which a neutral person facilitates communication between the disputants to reach a mutually acceptable agreement. Anybody, 1115B says, anybody that assists the mediator to convene the mediation or to communicate with the participants for purposes of confidentiality, they're considered a mediator. So all of those pre-mediation conversations called mediation consultations, that's a communication between a person and a mediator, remember, including the assistant to the mediator, for the purposes of initiating, considering, or reconvening a mediation or retaining the mediator. What does that say? Hey, we're neutral, we don't take sides, we're there to primarily facilitate communication to help folks reach an agreement that's mutually acceptable. Basically, anybody that assists us during this convening process, they're part of confidentiality, and they're described as a mediator under the statute. And the confidential communications start from that very first phone call, because that's when somebody calls us to consider. So if we call to confirm a mediation in dependency court and they start talking to the person who's confirming the mediation, the court doesn't want us to talk about it, but generally speaking, the law protects that communication. It's a mediation consultation. Even if those folks don't show up to the mediation, those are confidential communications. Again, we make a promise that we're not even going to tell people who's in the mediation, So it does say in section 1122 that if you're contacted about serving, that you can release that information. And most private mediators release that because they have to disclose if there's any conflict of interest. We promise to even keep the identity confidential. So we go one step further than the average private mediator. Okay, so I'm going to not go to every provision, but one of the things that I want to tell you is oral agreements are not enforceable or admissible. So if I say to you, is an oral contract potentially enforceable and admissible in a court of law? You're all going to say,
Yes.
yes, okay? If it's an oral mediation agreement, it is confidential, it's not admissible. So in order to get an oral agreement in front of a court, it has to be recorded under California Evidence Code Section 250. Anything that's recorded is automatically a writing in and of itself. It has to recite the terms on the records, and the parties have to expressly say, we agree to those terms. They have to also put in what I call magic words. So the parties to the oral agreement expressly state on the record that the agreement is enforceable or binding or words to that effect. So there have to be magic words in any mediation agreement for it to be non-confidential, saying the parties want it to be binding, enforceable, and admissible, non-confidential, something like that. There has to be some magic words. So if somebody signs a written mediation agreement and it doesn't have magic words saying the parties intend for this to be binding, enforceable, and admissible, non-confidential, one of those magic words, if it doesn't say that, it's a confidential mediation writing. Yeah, it's not like a regular contract. And then the statute says that that recording has to be reduced of what we call a regular writing within 3 days or 72 hours. So again, oral agreements are a little bit different. So that's why you want to make sure that your clients walk out of that mediation with a written agreement. And the written agreement, let me jump ahead because here's what the written agreement section says. Remember, 1119B says mediation writings, those prepared solely for the mediation, confidential. So now how do you take that confidential mediation writing and turn it into a potentially admissible non-confidential writing? 1123 tells you how to do it. It has to be written. It has to be signed by the settling parties. And it has to provide those magic words. Here it is, admissible or subject to disclosure, enforceable or binding. And then it says, well, you can do it if you satisfy 1118. We already know 1118. Same thing. Writing, signed by the parties, and contain magic words. So anything in writing that you want to get in front of a judge, hey, if it's our paperwork, which is essentially 200, 205, 134C and E, it's either our paperwork or it's the writing that you're getting from the other mediation program on Wednesday, Thursday, Friday. It must be signed by your clients and it must have magic words. Okay, so let's go back to 1119, which is what you really need to understand. Remember, I already told you the really most simple form. 1119 says that mediation, discussions, admissions, conversations, confidential. The statute you can see here, no evidence of anything said or any admission made. Where? For the purpose of, in the course of, or pursuant to a mediation or mediation consultation. Even if the mediation doesn't go forward, technically, if you're talking with your clients about getting them into mediation, technically, that's a mediation consultation. Under the law, there is case law that says that the communications that are not in front of the mediator, that are substantially related to the mediator between sessions, confidential mediation communications. That's part of why we got 954. So I'm going to give you the 3 minutes on why we have 954. There is a case called Consetn versus Superior Court. And what happened in that case is that it was a commercial dispute. I think it dealt with Von Dutch. And what they were doing is they're saying, we're going to mediation, and allegedly the attorney and the attorney's client agreed that they wouldn't settle for less than $2.3 million. I think that was the case. And that number could be a little bit off, but I think it's pretty close. So they go to the mediation, you know, they're in mediation all day long. So it's not dependency court, it's a civil case, the mediators, the attorneys are in the mediation all day long. So as the attorney's learning more about the case, I think there's an offer for about 1.3 or 1.5 million. And the attorney really thinks the client should take it. And the client doesn't want to take it. And so there are a bunch of things that the attorney allegedly did, and here are the allegations. The allegations are that the client went to the bathroom, the attorney followed him while he was going to the bathroom, stood there. The client felt badgered. The client, the attorney allegedly said to the client, well, if you don't take this settlement, I wonder who's going to be your attorney for the trial. So they had worked for many years together, and the client essentially was told, we're going to drop you if you don't take the settlement, and then you're going to have to find another attorney. And the client didn't think they could do that. The client left to go meet their family, and the attorney allegedly called them and said, hey, you got to get your butt back here, you know, that sort of thing. So basically, a lot of pressure and coercion. The attorney made the decision, not their client. The client felt that they had no option, so they took the settlement. Afterwards, they want to sue the attorney for malpractice. So it went all the way up to the Supreme Court. There was another similar case called Porter v. Weiner, and they allowed the attorney in that case to talk to the Supreme Court for a long time. And basically what they were trying to do is they were trying to influence the court to decide whether or not those confidential mediation communications between sessions, between the attorney and the client, are they confidential mediation communications, or are they governed by the attorney-client privilege such that the client can waive the privilege and sue their attorney for malpractice for what they did in relation to the mediation. And the Supreme Court said, no, those communications, even between sessions, even outside the presence of the mediator, that substantially relate to the mediation, that are substantially connected to the mediation. If there was a prior case, it was a husband and wife, they were having communications between sessions outside the presence of the mediator. That case was called Eisendraft. That court also held that those were confidential mediation communications, even though the mediator wasn't present. The Cassell case said those communications between attorney-client, confidential mediation communications, you cannot sue your attorney for what they're doing in mediation, no matter what, in a later civil proceeding. Okay, so, right? You're all thinking, great, right? Well, there were a lot of people out there who were saying, not so great. How can we have a system, how can we have a legal system where an attorney can do something that is potentially malpractice and the client has no recourse? So it really went through the Law Revision Commission for 5 years. There was a lot, I can't tell you how many people, including myself, spoke with them 2 or 3 times, and how many people weighed in on this. Trial attorneys, the judicial system, the court, et cetera, et cetera, et cetera, mediators. I think everybody was afraid, uh-oh, they're going to now start suing mediators. If they allow them to sue attorneys, they're going to allow them to sue mediators. So anytime somebody gets uncomfortable with what happened in a mediation, you know what the remedy is? Sue your lawyer, right? Because if mediation is airtight, there are no communications from the mediation that are going into a later civil proceeding, and you're stuck with an agreement you don't want, who are you going to sue? You're going to sue your lawyer, or you're going to sue the mediator for malpractice? So that's what happens in arbitrations. What they do is, when you go to an arbitration where the arbitrator does make a decision, the only way to really attack that arbitrator's decision, which is called an award, the only way to attack that is to say that the arbitrator didn't disclose a prior relationship, so that they were biased. So they usually attack the arbitrator. That's one of the only ways in an arbitration to get that arbitration final decision, not to be enforceable. So in mediation, we were really concerned. Look, the reason the courts love mediation is because we're taking cases off the court's docket. We're taking cases away from you guys. If anytime somebody was dissatisfied with whatever they agreed to, they have buyer's remorse the next day. If anybody's dissatisfied with that, you know what they can do? They could sue the mediator, they could sue their attorneys. So airtight, basically what happens in mediation stays in mediation. It's like Vegas. Unless it's a later criminal proceeding, then you can argue anything. And federal court is really different. A lot of people go argue to federal judges that you should open up confidentiality, and if nobody objects, remember, all evidence is admissible unless objected to, and a lot of times in federal court, they don't object, and the courts have done a lot of really wonky things from my perspective in order to get things into federal court. In a later criminal proceeding, I know of a lot of cases where people have really resisted it and the courts have accepted it, even though this statute in and of itself does not protect in a later criminal proceeding. Yeah.
So when you talk to Tony, because we have to, alert our attorneys that if they send a client to mediation, they need to double check to make sure that client doesn't have a pending criminal case, because we probably shouldn't be sending those folks to mediation.
Well, let's talk that through in a minute. I think that there is some concern for that, but let's think that through for a minute.
Right?
If you're sending them to my mediation, those two folks cannot contact me. They can't contact me, they can't subpoena me, they can't try to get me into a court. So what's going to happen in the mediation that could potentially hurt them in that later criminal case? Most people don't come into mediation saying, yeah, I really did this. Most people come in talking about
It's the family law order.
going forward.
Well,
Yeah, they don't
right
really
now-
talk about the criminal conduct.
Right, well, for right now, the only mediation, it used to be many years ago that we mediated everything. Now
Yeah, I
we're
knew
just-
Maxine well.
Right, so we're not doing that anymore, it's just narrow family law
Yeah,
orders.
well, it's
But-
going to change. They're talking about it changing right now.
I understand that, which
Yeah.
makes me very concerned about what we're talking about here, because one, I don't know if in mediation they're making it very clear that all the notifications that you're telling people does not include criminal cases. Now, our clients very rarely have anything to do with federal law. Once in a while, yes, there will be crossover with family law, but tons of our clients have pending criminal cases that have not been resolved by the time a case ends.
I can tell you they never talk about that stuff with me.
I
Do
know
you, Sarah,
that.
do they sit there and
But
talk about
as
the
you
criminal
know,
stuff?
as
Yeah.
lawyers, we have the obligation to tell our clients, and those notifications, I'm not sure, really explain to the client, one, that the person you're talking to, you better not talk about anything to deal with the pending criminal case. We get this a lot with our DV clients that may have pending criminal cases.
Well, and
that
you
they
now
do.
have an ethical duty under 1129 to tell people about the restrictions. So 1119, this is what's covered. What are the restrictions? The restrictions are you can't sue your mediator, you can't sue your attorney, and it doesn't protect any communications from coming in or not coming into a later criminal proceeding. Those are the restrictions of this 1119, which is what you have an ethical duty now to describe. Now, granted, they were responding to a lot of people saying there should be an exception to confidentiality to sue your lawyer. And everybody went nuts. There are a lot of people that said we need that. And this was the compromise. The compromise was that you have to tell your client about the restrictions. So the relevant restrictions are, you can't sue me. If I come to this mediation and I say, you're going to go to court and you're going to give 4 hours, you either agree with right here, or you're going to go to court and the judge is going to give you 4 hours. It may not be monitored, but that's what the judge is going to give you. You say that. That may be true or not true. Your client cannot sue you for it. So if your client accepts the mediation agreement because they're afraid to go in front of the judge because of what you told them, they cannot sue you for that, number one. But it's really relevant what you're saying is that it doesn't extend to a later criminal proceeding as well. So don't talk about anything that could be potentially related. We won't do those mediations at our center. If there's a pending criminal case, we say, look, we can help you with that, but only after, there's no possibility that you can come to the mediation and make an incriminating statement that could hurt you later on. We have a do no harm. Most mediators don't have that rule. We have that. So we do we're very careful about that. A lot of legal aid offices, they say, we're only sending them to you because we send them over there, we have no idea what's going on in that mediation. That mediator, we think they're going to put pressure on them, but you're right. So what are the restrictions you have to describe? Well, we've just gone through them and you just pointed them out big time. and then you have to decide. I don't think it's such a problem, because they never talk about that stuff. They always talk about what they want to do with their kids, and then they want to go forward. And that's really all the time we have, especially because if we get them at 10 o'clock, by the time we've got the file and we're oriented, we've talked to each of them about what the process looks like, we've received some input. By the time we possibly get an agreement, it's 1:30 or 2 o'clock in the afternoon. We have 2 hours to write up all those forms, and then we have to review the forms because it's their mediation agreement. We don't have anybody sign anything unless we've reviewed it, and we will take the English agreement and write it into Spanish.
And what's going to happen in the future if mediation now opens up to the actual resolution of the underlying issues? If mediation becomes true mediation with settlement as to the underlying allegations and the possibility of criminal.
I think we're a ways away from there, but I could be wrong. Yeah.
So I understand that this new law gives the effect that your client cannot sue you on the basis of communications that occurred in these confidential mediation.
Or in relation to
Or in
that.
relation to it.
Yeah.
Does the effect of this mean that they can sue you on the basis of not providing the mediation disclosure, notification, and acknowledgement up front?
No. If you look at the acknowledgement, so they can't sue you for malpractice.
Well,
And it's not a basis to set aside the agreement, but they can file a claim against you at the state bar. But guess what?
well, your
They
note,
could do that before this.
your note on the agreement says that it does not limit your attorney's potential liability to you for professional malpractice or prevent you from.
Where does it say
XYZ.
this?
On the mediation disclosure, notification, and acknowledgement at the bottom of all the
That's not
type.
mine. That comes, the mediation disclosure is part of the evidence code.
Right, so directly
it's not
from,
mine.
so directly from the evidence code, it doesn't actually prevent them from suing you. It just prevents them from using those communications as the basis for it, right?
Yes. Oh,
Okay.
yeah.
Okay.
I mean, these are confidential. You cannot say, my attorney committed malpractice in the mediation or in relation to the mediation, so I'm going to sue them. So that's the disclosure. The disclosure is, hey, you might be able to sue me for what I'm doing generally representing you, but for any of the, you remember, all evidence is admissible unless objected to. So if you got sued for malpractice and then they try to say, hey, you know what else that attorney did in mediation? You'd have to object to it, and you know, it would win. If you don't win and that gets in and you're found to have committed malpractice, it's a motion for setting it aside as an irregularity under, I think, 1126, I think is the statute number. So attorneys are really protected from what they're doing in relation to the mediation. You know, anytime somebody made a really good argument in a later criminal proceeding that I know about to not subpoena the mediator, it has worked. I can tell you that people are not talking about their criminal cases in our mediations ever. There's very little time. It's a focus on, I want my kids these days. And so again, you have a duty now to tell them the restrictions of 1119. The restrictions are any of the mediation discussions or writings, those won't come in front of the judge unless, now you know that the court requires the mediators, if there are any new credible allegations of abuse or neglect, we say credible. Why? Because any person can come in and make an allegation about the other person to create some more trouble. If they do that, is it credible? But I can tell you, most people, by the time they get to us, at least now, with the way the program is now, they want out. They want to agree. They say, oh yeah, I don't like it, but I'll have to deal with it in family court. We want out. They're not creating additional conflicts. They're not making new allegations. I once, and usually if they're making new allegations, they're not wanting to settle. So there was one situation where somebody had said something, and I did report it to the clerk. And they didn't settle, and I don't think anything happened as a result of it. You know, people are so overwhelmed, from our experience, people are so overwhelmed with the enormity of these cases and the number of cases, that a lot of times things go like this. I know that that's not necessarily best attorney ethical conduct, and that I like the way you're thinking, and I'm a nutcase about confidentiality, about not hurting people in our process, and people will say Mary Culbert's a nutcase about confidentiality, and I'm okay with it. So I would just say that I'm really not worried about somebody being harmed in a later proceeding as a result of what we're doing in our mediations.
So once signed, Is there such thing as buyer's remorse if the client says, oh, I signed it, signed it, you agree, it's coming up to the department, and they're like, oh, I'm not happy with this? What do we tell our clients at that point?
Well, what we do is, remember, the judge, it says right on our agreement, the judge, you're only saying that you hope the judge will accept this, but the judge doesn't have to accept it as your exit order. So you can always argue something else. Does that mean they have an agreement? Yes, but if the judge's order will certainly supersede their mediation agreement. So what we do in the center, we have a lot of people that come in and do their divorces. They all have buyer's remorse. They just come back until they feel good about it. With you folks, yeah, they can have buyer's remorse until the judge signs on those forms that it's probably not, they could take this to a court and say, here's my mediation agreement, it's enforceable, but it says right on the mediation agreement, and all parties agree that they intend that this mediation agreement shall be enforceable and or admissible as evidence, and that it will be given to the court at the completion of the mediation so that it may serve as the party's exit order upon confirmation by the court. This agreement must be signed to be enforceable or admissible. All parties understand that this does not mean that this agreement will be enforced and or admitted. All parties understand that this only means that they hope it will be. So the reality is, it's not a court order until you get out of there. We're doing something confidential in a confidential court system. So what I think is that a lot of times they leave. So you guys say, well, they've signed it and they've resolved everything, so they can go home. We don't have any more time today. The judge will hear this tomorrow, as long as they've signed and they feel okay. Most of the time they go home thinking that. If they have one or two issues that they can't agree on, we say, well, we can write everything else that you agree on, except for those one or two issues. You can see, number 4, all parties agree that the following issues were not agreed upon in the mediation and will need to be decided by the court. So we have to negotiate that. And then we write that down. A lot of times that's how we get a mediation agreement, because there's one or two things that it's a feather in it's a craw in their cap, as they say, and they won't agree to it. And so then we say, well, you've agreed to so much, you worked so hard today, we can write that up if you want that to be part of your exit order. And sometimes they don't want what they've agreed to if they don't get something else, and so they say no agreement, and they'll just go to the court. But most of the time they want it written up. So I don't know if that answers the question. Yeah.
Thank you.
Thank you, guys. See you. How are you? So read section 1120 through 1125, because those are the ways